Thank you so much. I first of all thank the organizers Legal World for preparing the lawyers for a changing world. Friends, it's a great opportunity to have a very heavy panel immediately after a heavy lunch. See, this talks about the changing dispute resolution paradigm. We have all seen in the last 15 years so many changes in the area of dispute resolution. The latest one is the influence of artificial intelligence coupled with a lot of data protection, cyber attacks, so many other exciting things, including the technological loss development. The first one started with, you are all knowing very well, the gearing up of arbitration started when the ancestral model law was introduced all over the world in 83 nations around 1990. Then things started changing very fast. Couple of seats like London, London, New York, and Paris started growing like a big arbitration centers. After that, which was a big shock for the entire world, was given by Singapore and then Hong Kong as a very more attractive arbitration seats. And some innovations came in like DAFC arbitration, Qatar International Arbitration Center, trying to come away from the national courts style of working, law, applied law. And then countries like China picking up in domestic arbitration starting about 700 arbitration centers, institutional arbitration centers in China, and developing a huge institutional arbitration backup. And countries like India, which was having more than 99% of the arbitrations as ad hoc arbitrations, with the help of institutions like Mumbai International Arbitration Center, Nitin is here. We also started looking into international arbitration, and the whole world started changing in this paradigm of arbitration. On the other side, commercial courts came in. Commercial courts came in and gave a direct competition to the arbitration process, because commercial courts had the systems established as well as they wanted to expedite the process. And the new innovations came in like International Commercial Court of Singapore, which tried to bring in foreign parties to Singapore even for commercial litigation. And we also started realizing some importance. So we brought in commercial court system in India. We started recognizing some countries. Even today, we have not recognized UAE as a New York Convention recognized country in terms of arbitral awards. But we are recognizing UAE as a place recognized for enforcing the judgment and degrees in India. So commercial paradigm also is changing. On the other side, mediation picked up very well, and we were all thinking that mediation is only meant for matrimonial disputes. Now very complex commercial disputes are being settled by mediation. And after Singapore Mediation Convention, still things are looking up much better. Even Niti was telling MAAC also will come out with some rules for mediation. So things are totally changing. Now at this point of time, you will have many questions. I also have many to the panelists. Our opening batsman is Rajiv Malik from LG. Rajiv, now every discipline of life is getting hugely influenced by artificial intelligence. You are a GC, you have an experience with artificial intelligence as well. How AI can help running your regular duties as well as preparing or preparedness of your future litigation or arbitration? How you are seeing that?
Yeah. Thanks, Ravi. Before I answer to your question, because it's a heavy lunch and we are feeling like that it is going to a boring session, so I would like to start with the one poem, right? It says, in the realm of AI, disputes resolve. The age of tech where problems resolve, a promise for tomorrow, radiant and clear. With AI's might, conflicts disappear, right? But now that's our wish. But actually whether it will disappear or it will increase, that time will only tell. This poem was written by me, but with the help of AI, right? Now the question arises, who is the copyright owner in this case? AI or myself? Incidentally, I have asked my son, who is just in 9th standard, although I think he is acted biased with me because he gave credit to me only, because he said, no, because under your instructions, AI has worked, so you should be the copyright owner, right? But still, answers remained as it is, right? So we can discuss, and we have the very good panel who can deliberate on these issues. Another thing, one more thing I would like to your all attention to the word newfangled used in our topic, right? Which actually indicates that AI can only be used where stakes are less and where we can anticipate the mistakes. We can accept the mistakes. My advice, otherwise we can see, AI can, if we want the accurate results, then we cannot 100% rely on the AI. There is lot of research is to be done. Only then these things can be accepted. Otherwise, it can lead to many mistakes and many errors. We have actually have seen one lawyer giving the precedents in the court, and it incidentally came out that all the precedents given by the AI, the Chatterjee, were fake, and actually they didn't exist, right? So these are the things actually in-house counsel I have to take care whether we can totally rely on that or we cannot rely. We can actually rely on that. But still, coming to your question, there are many areas. Actually, I am in favor of AI, and that's why I have written poem also, right? And where there are the cross-border disputes. That is the one area. Online dispute resolution, another area. In electronics industry, consumer cases are, so many consumer cases are there. There we can use the AI. And in fact, with the company having the multiple jurisdiction, right? There also the compliance requirements in different jurisdiction is different. And there actually AI can be very helpful. But only thing here, the caution is, if you are using the general AI, then it is very difficult to adopt. But if you are having the specialized AI, the data set is there where you can have the correct inputs, right? Only then you can get the correct results. Suppose if the data algorithm is like that the data is input is biased, then of course the output will going to be biased. So these things I think we can take care. Another thing, another area where I'm looking at, if we recently Apple has launched their new headset, headgear, the Vision Pro, right? It's like you can actually, the 3D is already there, but the images, actually you can have the real-time images. You can feel it. So arbitrators and the litigants actually can wear that headset and actually visit the construction site where the disputed site is there, or you can go to the accident site, or in case of in consumer industry, if you're having the product, you can actually see the product, how it's working. So it is so close that these are the things the technology is going forward, and these are the areas where actually we can use it, but of course with a caution. Thank you.
Thank you. Now I request Dr. Raghavendra, Additional Secretary, former Additional Secretary of Government of India, Ministry of Justice, to supplement your views on the AI's influence over the dispute resolution system.
Thank you. Artificial intelligence, it's only a machine. It's a general purpose assisting technical tool. And it is being employed, of course, in legal sector. The e-courts phase 3 project has been finalized, which is considering seriously to introduce AI and data analytics to improve the court functioning. You know, AI, including in arbitration, is being used in Canada, US, and many developed world. AI is being used especially to solve the cross-border issues. You know, my experience of free trade agreements and bilateral agreements, where the issues come up, clear paragraphs have been written, arbitration happened where, and what are the contractual issues if performance is not happened. So case will be filed in which case, jurisdiction, everything is made clear. So AI can help in this matter, any kind of dispute comes, and also cross-border disputes come. But problem with the AI is the standard AI standards have not been developed. EU has come out with the draft act. If different AI standards are there in different jurisdictions, what will be the problem? The technology standard, I'm saying, similar to the standard essential patents point of view in that context. So these issues will come. Then AI can select an arbitrator out of the panel. There should not be any repetitive arbitrator or arbitrator lack of information is selected and imposed on the parties. That will not happen. AI can help that. AI can help in other additional job done by judges, because in the implementation of the commercial courts, when commercial courts were introduced in 2015, we introduced the district judges at the commercial court level in Delhi, Mumbai, starting with, then Calcutta and Bangalore we started. How to improve the functioning? Of course, we introduced the pre-institution mediation, amending the 2018 Act. There was a dispute between the with own sister department, the law ministry. Finally, there was a meeting where I intervened and told the PMO senior officials they liked the idea of the pre-institution mediation. That happened. So that has opened up the new windows where mediation can be done before going to the trial, commercial trial. And then we also introduced in the CPC amendment, the case management hearing at a pre-trial conference, again expedite. So each and every stage AA can help, even recording the evidence and in especially the descriptive analysis. The deep planning things come tomorrow, the descriptive analysis and the prescriptive analysis, even predictive analysis, and giving the arbitral award. Only thing problem is here, the lack of human touch in that, whether
Yes.
sympathy, empathy, these things will come. And then coming to the international commercial matters, as you are aware, the Government of India earlier had come with the New Delhi Arbitration Center. Now it has been renamed as the India Arbitration Center, basically to give a platform to all the legal community who are into arbitration. Why you go to Singapore, London, everywhere? You know, why the reason why you go to arbitration, from mediation to arbitration, because it's speedy resolution of the matter, less cost involved in rather than in the longer court battle. So this can happen in India when two parties are from India.
Yes, yes.
And again, one more thing, we started, some of the people attending here aware that online dispute resolutions. We have selected the top online dispute resolution bodies in India, and we recommended those 18, we even uploaded 18 names, recommended all the ministries and departments, even the state governments, please engage them
Yes, yes, sir.
and try to go ahead. And even online dispute resolution also, AI algorithms are being introduced there for the speedy resolution of these disputes through online. The same AI, the way it is functioning, helping the judges in the case management, court management, and various other, help which a judge needs. Apart from the out of the court, how lawyer is using
Yes.
in the legal research. Mr. Malik already mentioned about the US, where a lawyer with a, he was fooled by ChatGPT. 6 case laws, it suggests that no court has given decisions. So even if you see the ChatGPT at the end, it gives that it has its own limitations and it may give wrong information. So fact checking is important. When a lawyer doesn't do fact checking, who will do? But AI is going to change the entire legal scenario, whether the way court functions, case management, court management,
Yes.
and the giving the dates and reducing the time taken for the dispute, and mostly in arbitration also, same way it can be used about the evidence examination and various other. I'll come back again.
Yes, sir. Thank you. Mr. Kinshuk Chatterjee, you are a counsel. So, what is your view on the AI's influence in the case management of
can I be heard?
arbitrations and dispute resolutions?
So I'll just add on to what my co-panelists have already highlighted. Artificial intelligence does have the potential to increase efficiency. There's no doubt about that. But then, as was already highlighted, there are issues of bias, transparency, and accountability. Because the data, the deliverable that we are getting, or the delivery that we are getting essentially from the AI, that is the data that has been trained on. So whether it is about these false cases or any such mechanism, we have to be conscious of the fact that the regulation is yet to develop because it's all very new and we are still grappling with the newness of it. So there is a policy vacuum. Secondly, what are the areas that we can actually use AI, where it can be of assistance? Complex arbitrations are not essentially binary. There is no yes or no, this is right, that is wrong, because of the complexities involved. So tasks such as research, structuring the data, the material that is placed before the tribunal by the parties, using the AI to figure out certain precedents, predict certain possible outcomes. I think these are the areas where AI can be definitely be of assistance. And perhaps what can also be considered is some sort of a hybrid model where we have an AI arbitrator and a human arbitrator, where the human arbitrator is also relying on that AI system to throw out certain possible outcomes for the arbitrator to actually consider and then render the award.
Thank you, Mr. Chatterjee. It was a fantastic thinking. I am also thinking a day will come, AI will become like an expert witness coming before the tribunal and giving certain findings on the technical issues. Now, let us go to another area of interest, because as Mr. Raghavendra was telling, now mediation has become a precondition to go for any commercial litigation. In such a situation, even today there is an apprehension whether very complex disputes can be settled effectively by way of mediation. So I request Mr. Sameet Gambhir to start.
Okay, thank you very much. So I think AI is so much in our mind that, whenever we go in any legal conference, even if the topic is AI or not, we are always discussing about AI, always discussing about the
Yes.
Chatterjee and all, that. So in terms of, that's a good topic. In fact, mediation is, we really see a lot of potential of mediation in India. Internationally, we have seen actually. I was reading somewhere that, in the case of Lehman Brothers also, they went into the mediation finally, and, out of around 70, I think for 65 were settled through mediation, and then 4 or 5 were dismissed or something. So it has a lot of potential, and particularly when we have the draft bill ready now and we are in the gearing mode that we are gear up now for the mediation. So I think the only thing we need to understand is that the biasness issues and the other issues, because if we really see the mediation is governed by the courts and governed by the government of India and all other regulatory things, then it will be little, there could be some bias things also. But otherwise, I see that mediation has a lot of potential, provided the mediators are elected properly or selected properly. Because when you are making the panel of mediation, now I've been seeing that, the panel has been started and, people are making panel. So while selecting the mediators in the panel is very important, that the people of substance are there. It's not necessary that all the legal person should be there. You have to have other people also, and possibly, in the big mediation, I think there should be some co-mediator also who is, maybe subject matter expert or legal expert or someone else actually. So keeping in view in that, I think we see a lot of potential. हालांकि on the lighter side एक बात बोल देता हूँ कि हिंदुस्तान के अंदर लोगों का जो पारा है ना, मतलब जब दिल से निकल जाता है तो दिमाग पे चढ़ जाता है एकदम से। तो बोलते हैं अब मीडिएशन किस लिए यार, जब तक थे साथ तो थे, अब तो सीधा कोर्ट में मिलेंगे यार। सो एक माइंडसेट जो मीडिएशन का है ना, वो भी लाना बहुत ज़रूरी है हमें। कहीं मैं पढ़ रहा था कि अगर रिश्तों में अगर बचाव की कोशिश की जाए तो रिश्ते पूरे ख़त्म हो जाते हैं, दैट मीन्स इट्स ऑलरेडी एग्जॉस्टेड। So mediation में every party has to have a mindset that there is a possibility of resolving this or resolution of this, then we should go for mediation. Otherwise, just for the sake of mediation, ठीक है यार, जज ने बोला है, कोर्ट ने बोला है, mediation try करो, we try mediation, and then finally नहीं भैया, because we people are very emotional, particularly in India. We mix emotions with the business, and when we say in the business, then there is a tussle. ठीक है यार, tussle है तो tussle, and now there is no mediation at all. We'll see you in the court. So that mindset has to be change in the mediation scenario.
Thank you so much for the nice inputs. Now I request Nitin, Mittal to throw some light on mediation in terms of cross-border transaction and issues, if you have.
So I think my co-panelist Sumeet has given a good view. Mindset is very important in mediation.
Yes.
And I think as an in-house counsel, mediation is sort of a prevention pillar. So one of our key jobs as in-house counsel is to prevent disputes. Now, if you can prevent disputes, part of our success is there. And business is not there to dispute or litigate. It is there to run business, make money, also serve the society in a certain sense. One of the things that I see in mediation, whether it's a domestic dispute or a cross-border dispute, is that people just don't read contracts. It is only the lawyers who read contracts. The business people, they're not aware of their rights and obligations. They say that, okay, this is an issue. For example, as Sumeet also mentioned, ego issues. If you are aware of your rights and obligations, any balanced person will feel that if you mediate, if you sit across the table, there could be a solution which is a win-win for both the parties. Now, from a cross-border dispute perspective, mediation is much more important because when there are two countries, there are cross-jurisdictions, cross-country laws, it is much more complex. So mediation is much more important when there are disputes across the borders because you will save a lot of money, you will save a lot of time, you will save a lot of opportunities, and also manage risk in a very sensible manner. But the only solution to that is to bring about a mindset and bring about an attitude and also encourage people to read contracts and to know about their obligations, because sometimes people only read their rights, they don't read their obligations.
Yes.
So that is also an inherent problem. Also, so cultural aspect is something which is also important. In countries like India, there is a different cultural concept, like Sumeet mentioned, ego. Maybe in certain other countries, ego is not an issue. There are certain other aspects. So when we consider mediation, I think cultural aspect needs to be also thought through. How does culture play when we want to mediate? Because that is also a strategy that you need to really recognize. Because ultimately, resolving disputes is also managing relationships. How do you manage relationships? How do you manage perspectives? And win-win for both the parties.
Well said, Mr. Nitin. The takeaway from both of you is we required trained mediators as well as a mindset to accept the mediation results. Thank you.
One more point is that I think mediation, the mediators should be experts in the field of dispute. Yes. We cannot have general people resolving mediation disputes, because if you have an expert, if it's a petroleum dispute or an energy dispute, if you have experts in that area, it should not be lawyers, it can be technical people. I think they will add much more value. Otherwise, it gets very technical, legal technical.
Yes, that's a very important point, because a domain expertise helps a lot, particularly in mediation related issues. Yes. Now, Mr. Sameet, Chugh. See, now India also has implemented a commercial court system. On the other side, some matured jurisdiction like UK and Singapore has come out with an international commercial court system. What is your take on that? Will it really help us to expedite the processes without diluting the, you can say, procedural aspects of litigation?
So thank you. I think, in order to really answer that, we have to go back a step and see what is the intent of the commercial courts. The start point of a commercial court was really to turn around and take care of really disputes which are more commercial in nature versus legal in nature. And I think that's the important part. So commercial courts are something which as a thought process and as a concept are extremely, extremely important and relevant. Unfortunately, there are two things that have happened. One is the fact that the commercial courts have got overpowered by the legal part as opposed to the commercial part, which is why the effectiveness is not as good as what, say, a Singapore has or some of the other places has. And that's where I think we as a legal system need to step back and rectify or turn around and really say what is it or where is it that we are failing. So unless and until we then turn around and say in a commercial matter, in a commercial dispute, the primary motive of a commercial court is to see the commercial issue, deal with the commercial issue and come out with what I would typically call a judgment, or for that matter a decision on commercially what is correct or who is correct commercially, versus the fact that you go into the legal part and then you keep getting involved in the legal part and people have forgotten the commercial issue. Plus the second part there is also that commercial disputes really are critical. Why? Because it's all about money at the end of the day, and we should take a step back and kind of really think from a business standpoint. As a business, what is more important for me is, yes, I have to do the right thing, no doubt, but ultimately I have a certain amount of money that is out there. And if I am, let's say, Sameet and I have a dispute on a particular contract where the issue is money and I'm a small business. Now, if my money is stuck and is going to be stuck for the next 5 years, I am dying as a business. Forget commercial dispute, forget commercial solution, commercial court. I am dead. There is nothing left. So this is a classic case of, operation successful, patient dead. So that is how it is. Yes, so to me, I think commercial courts have the ability and the wherewithal to really become big. They were meant for a certain perspective and a certain reason. That is what it should be. Unfortunately, we've lost that part somewhere. So if we can bring that back, I don't see why India cannot be as good as a Singapore, or for that matter, why can't we become a commercial court hub in the world?
Okay. Thank you, Mr. Chugh. Mr. Chatterjee, you had some special experience with UK commercial courts. Can you throw some light or differentiate what difference you saw there?
I'll just add on to what Sameet said. When we talk about commercial courts, it is extremely important and time sensitive because it is the money at stake and it is the value of money that is dwindling. So given that, my experience in London has been that, the commercial court in London is extremely organized, and the entire system is devised such as to increase efficiencies. I'll give you a small example. Something as rudimentary as filing an application for extension. Maybe you had a deadline and you need an extension. Now in India, you would probably spend time fighting on it. Maybe there would be an application, make a paper book, file an application, hearing. There's so much of time that is gone. And not to mention the costs, of course. Typically what would happen is in London, if you would go to the High Court website, download a general application form, fill in the details, and why the party is seeking that extension has to be explained in literally a small box that is given in the form. If you need to say something more, then at best you can add a witness statement, which is 2 pages at best, and that too by the solicitor. The party doesn't even have to get involved. There is no formality of notarizing, etc. You simply take that. You, in your office, you prepare a consent order. You basically prepare and put in the language that you want the court to stamp on. You go to the court registry, give them the court fee, which at least that point of time when I was there was, I think, something nominal like £20 or so. And within 4 or 5 days, you will get a call from the registry to say that the application has been approved. You can collect the order. And the order will come in the same lines as you had proposed. So you see, these little things save time. And once the pleadings are over, the first thing that happens is something also that we are now replicating in India, is a case management conference where the barristers from both sides will stand together. They will tell the judge that, look, these are the issues, this is what it is, these are the timelines. So sitting in June of 2023, you have your dates set out till about September or October 2024, which includes the time that will take for the trial. So both the barristers agree and they sort of come to a consensus that the dispute is complex enough that we will take 3 days or 4 full days of the court time, and the judge will be given a reading day before the trial commences, which means that if the judge on, say, a Wednesday is doing nothing else but actually going through the papers that he has to sit, read, understand, and adjudicate on tomorrow. So there is no time spent or squandered trying to explain things to a judge, etc. So all of these, the coalesce of all these factors, they add up to making the system very efficient.
Thank you, Mr. Chatterjee. It's a very interesting example. Now let us go into an important point. I'm starting from Mr. Sameet Chugh. In your opinion, which are the areas that are going complex day by day in view of the diverse and complex regulatory demands globally as well as in Indian market? I want all the 4 GCs to explain. We will have.
So I think, as technology keeps, kind of improving, as technology keeps coming in, everything's going to get more complicated. And when I say more complicated, means that there is a regulation on one side. So any sector that really is regulated today will see that issue. So there is regulation, there is technology, there is humans, and there is commercials. So when you add this mixture, it's like a deadly combination. So anything, kind of really where there is a regulated environment, and given the fact that the regulations are not necessarily will be able to keep pace with how the world is changing, and that's the reality that technology outpaces regulations by miles and miles and miles, because technology develops very fast. Before you realize and you start to think about it, technology is kind of changed further. I mean, if we to take those 4 parameters into consideration clearly, and going back to really the commercial dispute, obviously the commercial disputes, or for that matter even kind of how the whole dispute piece will get done in a regulatory environment is going to become more and more complex. We have seen this in the past, and more so then you add to it the whole court process, and unless and until we can turn around and simplify those processes, unless we can expedite those processes, unless we can make it more relevant, the complications will never stop, and they'll only continue to go ahead. So if as an industry, or if as a GC, I have to say, really, kind of regulated industries can look forward to more exciting times, not necessarily the most positive exciting times, because you'll be fighting more and you'll be turning around and really having that battle all the time. I think some of the tech areas will grow. AI will kind of keep taking over. AI is here to stay. We may fight it, we may shun it, we may do whatever. AI is not going anywhere. That is the future, at least till we decide and are able to see how AI will help us. I think it'll have problems, but eventually when we are able to figure out that it has to be used in the right manner, there may be some simplifications there. But anything that's regulated, and as long as you're not able, or if you are not able to turn around and really work with the regulators well, and the regulators are not aligned and they're not really thinking forward, I don't know what happened.
Thank you, Mr.
I just want to add here.
Mr. Rajiv, please.
I just want to add here, but he's saying that regulations generally the miles away from the technology, and actually it's my take is that it's actually good, right? Whenever you see then new things are coming up and we start regulating immediately, then it will kill the creativity. So it is for the creativity and for the development. Actually these things regulation should come later on. We have seen in the e-tailers case also, there was no regulation. They were allowed to groom, and then later on regulations came, and then now we are talking of certain regulations. So it is better that regulations are not coming here right now, and we can fully utilize this time to innovate and be creative.
Yes, thank you. Thanks. Nice. Mr. Nitin.
No, I think, some of these regulations ex ante, right? And so one needs to not preempt technology and make regulations before. I think we need to first let the technology evolve, learn from it, and then make regulations. So ex ante regulations are something which are very difficult. But I also like to add a few more points. Is that from a dispute resolution perspective, I think there are a lot of unknowns. The world is changing at a very fast-paced level. Last 1 year, 2 years, AI. There are, for example, for a multinational company, it is much more complex because you have global regulations. For example, in Europe, you have the Digital Act which is coming. It may have impact on your operations, because we are connected. It's not an island. It's not an island, right? We are connected internet. Apart from all these digital laws, I think we also sometimes miss the traditional laws. In a business that you're running, you have complex issues of money laundering, anti-bribery. These also are evolving and becoming much more complex. So a lot of these civil matters, commercial matters also lead to criminal issues. So there is a lot of intertwining of commercial and criminal issues together. And as a general counsel, we sometimes have to deal with these issues. And how do we preempt these issues? How do we manage risk of these issues? So a lot of our job is managing the unknowns. And there is what prevention plays a key, and planning plays a key in dispute resolution.
Thank you, Mr. Nitin Mittal. Now, finally, to Sameet Gambhir, please.
So I think complexity है तो हम लोग हैं यार, सीधी सी बात है. We are there to solve the complexity. So there will always be complexities in the business. So I would say they are internal as well as external. When you talk about external environmental issues, regulators, government, stakeholders, when we talk about internal, we all have internal complexities which are much more increasing nowadays. Your employee issues, anti-bribery issues, corruption issues, then your policies, etc. Now, in this era of social media, technology, so the problem is the reputation risk is a very big risk nowadays. एक दिन कुछ होता है, next day immediately social media में छा जाता है. You have seen the case of TCS recently.
Yes,
what happened TCS में? So these are the complexities we are facing. Every legal counsel is facing in the organizations on day in day out basis nowadays, because you can't hide it now. The moment it happens, tomorrow it will be in the newspaper, it will be in the social media, it will be everywhere. People are talking about it. So I think complexities को handle करना, yes, it is a challenge. Technology is also making a little bit difficult in some cases, but I think for us it's good. The complexities, जैसे मैं बोल रहा हूँ, हैं तो lawyers हैं, and in terms of external, in terms of cross-border complexities, we see a lot of difference in culture, we see a lot of difference in legal issues, plus implementation difference. For example, in India, implementation may not be as good as in US for something. So all these things are there, I think, but yes, this is there, that will be there.
Thank you, wonderful response. Now, finally, to Dr. Raghavendra. See, one of the major milestones of the arbitration process, why you took up so well, is ancestral model law. That harmonized the arbitration law of about 86 jurisdictions. Is there any effort from Government of India or globally to have a kind of convergence, or you can say harmonization of commercial laws of the various jurisdictions?
Yeah, very good question. Ancestral model laws have to be revisited, especially in this emerging disruptive technological environment, and also the new issues, new cross-border issues are coming up because of the data privacy and other things. There should be new minimum standards have to be developed, and the new model laws have to come to address these issues. Because someone was mentioning about the commercial courts functioning. So what we have done when commercial courts were set up, I'm talking about the district level, not about the commercial benches of the 25 high courts. We made them compulsory. We used to have weekly meetings at my level. How many courts have started introducing e-filing? So how many filing? And Delhi always stood first. And we used to tell the Mumbai and other states, please, high courts, to follow this. And then came issue of problems of implementing the e-summons, lack of data, information, how we will issue, we don't have email. Then we had a meeting with the company, register of companies and Ministry of Corporate Affairs, and then asked them to prepare patch of their API and give it to us. And then we started pilot projects in Delhi and Mumbai. That worked. Now Delhi number of e-filing and e-summons, you just go to the DOJ website, there is a portal where data is given monthly update. Delhi stands first. And then we didn't stop there. We tried to educate people that look, there is a window called summary proceeding. Not a single case I've heard that. Then what to do this harmonization? International harmonization, ancestral model laws are there. There may be an effort to redo that. So what you have done, the UK commercial code guide, one day I downloaded, looked at it, and then I convinced my bosses that Indian commercial code should have such guide, at least. We can't copy and paste it here, but as per our Commercial Code Act and other procedures. Then we engaged NLU Delhi, the prepared draft, and they had a number of rounds of discussion with few sitting judges, few retired ones, and top advocates who are into business and commercial law. They are finally submitted. When the draft came, I ended my career in the government. Let's see what my colleagues should do that. So effort is there already at the national level, but international level, as you said, because only EU draft guidelines are very comprehensive, because Mr. Malik was mentioning about the AI learning models. They are clear that when AI learning happens, what kind of documents it is, indulging in data mining and learning process. What are the learning methods it has followed? So this is also important. Complete transparency should be there. That's what the EU Act is talking about. Unlike other jurisdictions, whether it is US or Japan or China has done. Again, there should be harmonization and minimum standards, which addresses the issues across the world, at least similar to that what we have the WTO technical standards and all that. And that kind of thing should creep into this regulation also. Otherwise, we don't see anything working systematically.
Thank you so much. Our time is up. I thank all the panelists. Yeah, please go.
Although I know I'm an opening batsman, but I still want to be relevant till the end. So that's why I'm making these remarks. And one more kind of disputes are coming up, like the ESG claims, where we see Sameet has talked about the reputational damage. So we have seen the Delta Airlines, where the greenwashing concepts are there. So as a legal counsel, actually it's our duty to see whatever claims we are making, either to the consumers or to the public, that claim should be verified by legal counsel. Only then we can safeguard and avoid these kind of disputes.
No, I agree with you. The greenwashing is a very, very serious issue. And it's a duty of legal counsel to see whatever is going in public. And particularly listed entities, your BRSR and all, these are very, very stringent things. And whatever is going in public, at least one has to really, really ensure. And it has to be, I think, it has to be driven at the board level, according to me, because this is something which is, and people are in the race now, because wherever you are getting a scoring or a ranking or a rating of ESG, so people think that put a lot of information.
And a lot of pressure on legal counsels also. A lot of pressure on us also to clear that.
I think SEC has made a task force in US that they've got many companies doing greenwashing actually.
Yeah.
Thank you so much. Thanks a lot, panelists. Now, you have any questions, please. You can come in the front.
So my query is for Mr. Mittal. He talked about the mediators, skilled mediators and infrastructural facilities in India. There was a judgment of Justice Joseph in Patel Automation versus Rakheja Builders. He talked about the challenges which we have in our country with regard to mediation and the burgeoning of mediation. Number one he talked about was the lack of skilled mediators, lack of a dedicated bar for mediation, and lack of infrastructural facilities, which includes the technological facilities for mediators. So how do you think what are the other legal, what are the other challenges for mediators in this country, and how can we, what steps can be taken to bloom mediation in the country? Thank you.
No, I think challenge is only, see, mediation is done through a private contract, right? It's a contractual dispute. So basically, I think business needs to understand that if you want to prevent disputes, mediation is one of the most better ways to resolve it. But I think one needs to have good mediators, and mediators does not mean that they are good in law or they are good in domain areas. First and foremost, I think they need to handle people better. They need to handle the soft issues better. They need to handle the overall system to resolve the dispute better before they move into expert areas. So personality of mediators is something which is very important, and that development can only happen in a structural manner. So maybe there is an institute, we have I think certain institutes in India which can further develop the curriculum for developing such type of people who can then contribute to mediation as a role, as a professional. I think professional mediators is something which is probably missing, I would say. So maybe that is something we can do.
Yeah, Mr. Mittal, thanks for your comments.
Can I just add there?
Yeah,
and I think,
please.
there's another part which is important, which is what, kind of Nitin kind of alluded to right at the beginning, is that, see, you can train a mediator. How do you ensure that the party is open for mediation? That is a big issue. And I think most of mediations will fail because of that. So in addition to, kind of really ensuring that you have trained mediators, you have processes, I think it's important that the parties who are coming for mediation are also explained what they are supposed to do. Because if I go in for a mediation or purely on the basis I have to just get this over and I have to now go to the court, no matter who you make sit over there as the mediator. I mean, I'm saying this in that many terms. You can make the President of India sit there. Nothing's going to come out here.
Mr. Chugh, thank you so much. But one of the reasons is we, lawyers, we don't want to give up the file. So we hold on with that on a lighter side. Thank you so much for all of your patient hearing. Over to the organizers for the conclusion.